Thanks for all being here today. So we're going to get started here. Just as a quick introduction, we're going to talk about wills a little bit here to start with and how they are a piece of the estate planning pie that we have. And I'm going to start sharing my screen, so it'll take me just a second to do that. So thumbs up, everybody can see that okay? Great. Okay, so we're going to talk, like I said today, about writing a will, which is just a piece of the estate planning pie, and when wills work and when they don't. So I'm Mark Peterson. I am the attorney here at Snake River Law. We've been in business since 2009, where we focus on helping families protect and empower themselves through estate planning. We also help families that have businesses, make sure that we can promote those businesses and help them be successful. And then we help with elder law. So as people age, some of the unique circumstances that they deal with as they age. And then we help with private adoptions and foster care adoptions. So that's kind of our practice in a nutshell. So starting off, first off, this is a common question we get is, what is the last will and testament? And so basically, a last will and testament is a legal document that expresses a person's desires or wishes about how their property should be distributed, and also appoints a person that's responsible to manage that estate and that property until final distribution. So those are the basic things that are part of a will. There can be some additional things added into that, but that is the basic idea of what a will is. So are there any requirements for a will? In Idaho, we have a couple of requirements for a will to be valid and enforceable. Now, this can vary state by state. So just because this is what it is here doesn't mean it's going to be the same everywhere. So first off, it has to have at least 2 witnesses, and one of the witnesses cannot be an interested party. So what that means is if they are going to receive something in the will, only one of those people could be a witness. So 2 people that are going to receive something out of the will would make it an invalid will if they are the witnesses. So it does have to be notarized by an authorized notary public. So those are the 2 basic requirements for a will to be valid here in Idaho. Now, the exception to that would be what's called a holographic will, which is a will that's been handwritten. So it has to be in the person's handwriting, and it has to be signed and dated. And so that is an exception. It doesn't come up too often. We have seen a few holographic wills, but that when it's done properly with the handwriting signed and dated, that would be a valid will also here in Idaho. So what happens if you don't follow those basic requirements? The will is going to be deemed invalid and not be accepted by the court system. So this is a common question that I get, that we hear, that people call and they talk to us about this, is, can I create a will on my own? And the simple answer is yes. As long as you follow the legal requirements for creating a valid will, you can do it on your own. The benefits of a do-it-yourself will is really just the cost, right? That's really the main benefit there. Sometimes there's some convenience factors, but really it comes down to cost. And the negatives of do-it-yourself wills that we see is that people use forms that are incomplete, inaccurate, they're outdated, and most often they're not compliant with state law. We see people leave out critical provisions in the DIY wills all the time. Something as simple as just distribution, they don't put that in there, or they make it so it's hard to understand. And a lot of times they fail to put their own representatives in there, and so there's nobody been appointed to deal with the will. Regretfully, mistakes are frequent and numerous in do-it-yourself wills that often lead to more problems than solutions, and actually create more of a litigation issue for people than actually solving the problems. So when we meet with people, we talk about a variety of different options. And so one of the questions that comes up frequently is a will the right estate planning solution for me and my family? And here's kind of a simple way to answer that question. So a will can be a good solution for you and your family if you don't have any minor children. Okay, and the reason why that's important is if you have a will and you have minor children, and something happens to you, the money, the finances goes directly to those children when they turn 18 with no restrictions, meaning they get it all at once. And wills are also not set up to manage finances for kids until they turn 18. So if they need help, they're 10 years old, they're 16 years old, whatever, before they become an adult and they need help, wills are not set up to be able to manage those funds and to help those kids. So if you don't have minor kids, a will could be the right solution for you. But if you do have minor children, wills are typically not a good solution. Another category would be no one in your family has any type of special needs or disability issues. Again, if these types of things exist and they receive an inheritance through a will, they are going to have the potential to lose public benefits, at least temporarily, as a result of that inheritance. So that would be anything from Social Security disability payments. It could be Medicaid for medical insurance for a disabled person, and the associated medical costs that would come from losing their medical insurance. So those are some things to definitely consider. So if you have somebody in that category of a disability or special needs, wills do not work. That's not a good solution for you. But if nobody in your family has those problems, a will could be a good solution. The next one is all of your children are financially mature and capable of handling an inheritance. So we have families where they are concerned about their kids or heirs receiving money directly. And if you have those types of concerns, wills are not a good solution because wills are outright distributions to the heirs with no restrictions. And so that means they get it all at once, no restrictions. And if they have a financial immaturity problem and you're concerned about them wasting that inheritance, a will would not be a good solution. The next one down is you do not own any real property, which is kind of the technical term for land or houses or cabins or whatever you might have from that perspective. So real property here in Idaho requires probate to transfer the deed or the title to somebody else when there's a dead person on that title and deed. And so if you don't own any real property, a will would be a good solution. But on that flip of that, if you do own property, wills typically are not the best solution, especially if you want to hold on to that property. Like take, for example, a family cabin or something like that you wanted to preserve as a legacy for your family. A will would be a really poor solution for that type of scenario. So wills will work good for people that have total assets less than $100,000. So financial accounts and personal property less than $100,000 in total value. If you go over that, then there's different rules that apply, but under $100,000, a will could be a solution to help transfer those assets to other people. And the last one there is you are okay with having to go through the probate process. Okay, so and I threw down there. So wait, what's probate? So we get that question a lot. I mean, what's probate? We don't know what that is. So let's go over that a little bit. So what is probate? So basically, probate is the court process to appoint someone to deal with a deceased person's assets and liabilities. Okay, so probate does have its purposes, but for most people, probate is required as a result of poor planning and not because of a necessity to go through that process. So here's a few little bullet points about what probate is, just to help you kind of understand what that is. So here in Idaho, probate takes a minimum of 6 months to process. So that's the minimum amount of time. The law here in Idaho says that a probate has to be open for at least 6 months. And it can go up to 3 years or even more, depending on what's going on in the probate case. Okay. And heirs, so take, for example, children, minor children, or whoever is inheriting their parents' money. They are the last to receive any inheritance. Okay, they don't get to have access to those funds. They don't get those funds until the end. So minimum of 6 months, and potentially more than that, depending on what's going on. So administrative costs are always paid first, and creditors are paid second, and again, heirs are third. And so they come in last essentially when you're dealing with probate. Probate typically costs $3,000 to $10,000 on average here in Idaho, because an attorney does need to be there to prepare the documents and to get those ready for you. There's a pretty big range there because every law office charges a little bit differently, and that's why that's the average that I've seen on bills. It could even be higher than that depending on who you're using. So, but that's the average cost. Court proceedings, so probate proceedings are all public record. Anybody can look at your will and anybody can see your estate filings to know what your assets and liabilities are. This is particularly troublesome when you have potential creditor issues. They can see all of that. They can know if there's going to be any money left over and file claims and pursue a payment through the public record filings so that they know that exists. Anybody can go look at that. So just remember, anybody can go look at that. The other issue with probate is sometimes a husband and wife have to perform two probates. So what that means is when the first spouse dies, they a lot of times the surviving spouse wants to sell property. They want to change their assets around, and in order to do that, they have to probate the first spouse to get them cleared off of all of those assets, in particular property. That's usually the one that comes up. Someone wants to sell a house, but there's a deceased person on the house, and so they end up having to probate that their spouse's estate in order to clear them off of that house. And so that essentially in that case, they're paying for probate twice. So once for this spouse that died, and then somebody else has to pay for it again when the second spouse dies. So that results in double the cost of fees and just the time associated with that. So we have one of the biggest common myths that we get about wills repeatedly is the statement that I have a will, so everything is set. I don't have to worry about probate. So that we hear that frequently, but the real fact is that wills do require probate, and they are not a solution to avoid probate. And that's something that we try to educate people on so that they know that just creating a will is not sufficient if one of your goals is to avoid probate. So I'm going to kind of stop right there for a second. I don't know if we have any questions from anybody about kind of this basic idea of wills and probate. If you do, you could just unmute really quick and you could ask questions and we'd be happy to answer those. Right now, we've got some more stuff coming up here in just a second, but I figured out this would be a good place to kind of answer any questions of where we're at. Or you could even put it in the chat, or Zoom has a function down there where you could raise your hand even, any of those functions, you could do that. So I'll give you a second here, see if you have any questions. Oh, something came up in the chat, so let me look at that. Oh, that's Presley adding a statement there in the chat. Okay. I'm not seeing anything pop up here, so I'm just gonna go ahead and keep going here. Okay. So are there, where probate can be a big concern for people and they want to avoid that cost, avoid the court proceedings, avoid the time delay that's associated with probate, we get questions about, are there solutions that avoid probate? So first off, we know that a will is an important thing. It helps do a lot of things, but it does not avoid probate. So it is not a solution to avoid probate. So are there things that do avoid probate? And so the main way that people can avoid probate is through properly created and funded trusts. Now, when they're done correctly, they do eliminate the need for probate. Okay. The most common type of trust you see is a revocable living trust. That's when you hear people talk about trust planning, that they're almost always talking about a revocable living trust. And so a living trust has all the benefits of a will related to assets and liabilities and how to distribute those and appointing somebody to be in charge. But it also eliminates the need for probate when it's done correctly. And the cost of probate is also eliminated. So when I say done correctly, trust planning has two steps. One, document creation, and then transferring your assets into the trust. So it's like a two-step process. So that's what I mean by being done correctly, is you have to do both of those steps. If you don't do the asset transfer, you're still subject to probate. Trust can manage finances for minor children, disabled heirs, or immature heirs until they're ready to receive the inheritance. And so if you have minor children, trusts are a great way from a planning perspective, to make sure that you can set out how you want them to receive money, like the timeline for that, what you feel is appropriate for them to receive money for. So a lot of times people are okay with education or health issues when they're minors, but they don't necessarily want them just to have money to spend on frivolous things at that point. A trust can also protect disabled heirs through special needs planning, so that they can receive inheritance without losing public benefits at the same time. Trusts are private and outside of third-party control, like the court system. So nobody really has any right to see what's in the trust or what the trust provisions are. A trustee has the ability to tell people, that they're not entitled to that information. And so that's a real big benefit of a trust, that it does stay private. A surviving spouse is not required to pursue probate when the first spouse dies, because a trust that already has those assets titled in its name just continues to operate. So that surviving spouse can essentially take control of everything. They can sell things if they need to, including property, without going through that probate process. So it makes it really simple for a surviving spouse to administer things and to just keep moving forward in their life. Trusts also allow you to build a family legacy for future generations. So if you have, some educational goals or other types of goals you have for your family that extend beyond just giving them money, trusts are a really good tool for that. And they can help set that up and plan for that, so that there is, that legacy of your family that can be built. And trusts, when they're set up correctly, they're simple and easy to administer. Your successor trustee, when something happens to the main trustees, they immediately have authority to take care of everything. They don't have to go to court. They don't have to wait any timeline. There's no 6 months to get things completed. They immediately have that authority to access all trust assets, including bank accounts, property, whatever it is. They have that immediate access. So it's really easy for them to step into the shoes of the original trustees and to take care of things and to just fulfill their responsibilities as a trustee. So one of the other things we wanted to mention, we've talked about estate planning, and that's kind of an umbrella term that includes a will, which we talked about, includes potentially a trust, like we just talked about too. But there's some other things that you need to do that are essential that would protect your person and also your family during your life. So we're going to run through some of those other documents that we think are critical to a complete and full estate plan that ensures that you guys are protected. Okay. Someone's jumping here. Let me think. I'll just hit admit there. So first would be a financial durable power of attorney. And we'll go into more detail here in just a second about what these are and why they're important. We have a medical power of attorney, a living will, and a living will is not the same thing as a will or a last will and testament. They're completely different from each other, but they do get mixed up a lot, where people kind of think that a will and a living will are the same thing. So a HIPAA authorization. So HIPAA is the Medical Privacy Act, Dementia Directive, and a funeral directive. Okay, so let's get into the financial durable power of attorney. And I just kind of starting off, durable is a real critical word here, because durable allows the power of attorney to remain in effect even if you're incapacitated. If it was just a general power of attorney or a limited power of attorney, they actually expire once somebody becomes incapacitated. So that durable stuff is pretty critical. Okay, so a financial power, durable power of attorney protects you if you ever become incapacitated, during your life, so remember, this is during your life, not post-death, by appointing a trusted person that can help make non-medical financial type decisions for you. And so this is again, if you're incapacitated, this is that trusted person that's there to help you and make sure that you're taken care of and is authorized legally to make those steps. So a common myth that we see is that we hear often is that powers of attorney continue to be valid post-death. So people try to use a power of attorney after the person that created it died. And guess what? They run into the problem of people saying, hey, we can't honor that power of attorney because the person's died. So the fact is, powers of attorney expire upon death, and you cannot use them after somebody has died. Okay. That's when we get into estate administration. So either trust administration or potentially probate with through a will. That's, post-death, those are the things that have to occur. Powers of attorney are only good during life. So a medical durable power of attorney is the next one. So this protects you by appointing a trusted person to help make medical decisions for you if you are ever incapacitated. So again, incapacity is a big part of these two. As long as you're capable of making the decisions, the decisions reside, stay with you. You have the right to do that. And your agent, the person that you trust to make those decisions, only can do it if you're incapacitated. Incapacity is determined by a physician, and so there has to be some type of certification. So you can't just say mom or dad is crazy, right? You have to have some type of proof from a doctor that is necessary. Okay, so living will. We talked about this. They get confused. This gets confused with wills all the time, and they are totally different documents that have totally different purposes. So living will is a document that allows you to express your desires and give clear directives to your family members and medical providers about the type of medical treatment, particularly artificial life support, that you would want if you are ever in a persistent vegetative state. Okay. So if you're in a coma, you're non-responsive, and the only thing keeping you alive is artificial life support, this document helps to clarify what you would want in that scenario. So to either be kept alive indefinitely, to have something, some type of middle ground, or even to have what people call pull the plug, take me off of that life support. This is the document that identifies that and sets that out so that your family knows what your wishes and desires are. So HIPAA authorization. So HIPAA is the Medical Privacy Act, and HIPAA is very strict on who can access medical information or receive medical information from medical providers. And so a pre-signed HIPAA authorization allows trusted individuals to receive that information because you've created that, you've signed that, and you've authorized them to get that information if it is ever necessary. We've noticed a lot here lately with just the COVID issues and with hospitals essentially shuttering their doors and not letting anybody come in or no visitors come in, that the only way a lot of people could get information was through phone calls to a nursing station or to somebody in the hospital. And guess what? If they didn't have a HIPAA authorization, they weren't allowed to have that information. Okay. And so that what we saw is we had people in the hospital that nobody could get any information about what was going on, how they were, if they were recovering, if they're, what the status was. And it got to be kind of a big concern. So HIPAA authorizations are really critical to make sure you have an open door when trying to get information. If something ever happened to you, you were stuck in the hospital, you weren't able to communicate, and you weren't able to receive visitors, this would allow the people on your authorization to actually be able to get that information and communicate with the hospital without having to have those roadblocks in place. So as people age, the concerns over advanced Alzheimer's and dementia becomes much more of a concern. And so we do a Dementia Directive that sets forth your desires related to if you get to the point where you need assisted oral feeding and drinking, that you kind of outline how you want that done and your preferences related to that. And it also sets forth your hygiene and comfort and in-home care options, and make sure that those are outlined so that people understand that those are also critical components of a dementia type scenario. So this is important because it helps to eliminate, elder abuse scenarios of being force fed, improper hygiene, or even negligent facilities that aren't maintaining the standards that they should. And then the final one, we have funeral directives. This appoints a responsible person for your funeral, burial, or cremation, and just to take care of those final affairs. And it also sets forth your desires related to funeral homes and disposition of your body and ashes. Like if there's something in particular that you would want to have happen, that can be outlined on this document. We see it more in the cremation scenario where people have specific desires about where they want their ashes placed, or whatever might go there. They can outline that in this document so that their family knows what to do or what their desires are related to that. Okay, so those are all critical estate planning documents that kind of complete that whole entire estate plan. And so between the will, the trust, and then these other documents we just talked about, the powers of attorney and medical directives, that completes your estate plan. So that's what an estate plan is. It's all of these things together. And a comprehensive estate plan would include all of these different elements to make sure that you're protected during life, and that you have a clear and concise plan as to what would happen after you're gone and how you'd want those assets distributed. Okay, so I'm going to stop right there really quick. Again, is that going over those critical documents, and that bring up any questions that anybody has about any of them? See another message in the chat. So kind of going back, Kirsten asked a question about going back to wills in particular, that if she asked, if through the probate process, can anyone see how much my kids will be inheriting if I only have a will? And the answer is yes, they can see that. So if you just have a will and you go through and you'll have to go through the probate process, at the end of that process, a closing order and a final inventory and accounting has to be filed, which identifies all of your assets, and it shows who would be inheriting those assets. So yes, somebody could get into the public record and find that out. The potential negative of that is then the kids could be targets essentially of people that are trying to financially abuse their situation and take advantage of them. So yeah, that does become open essentially for people to investigate. Another question here, Kim and Karen say, is there a specific form for dementia and funeral directives? Yes, we create a specific form for that. We have a document that we've created for both of those instances. And I think Kim and Karen, you probably have those. We could double check. If you don't, we can get those created for you, but I think you probably do have those. We'll make a note to double check on that for you. So then they asked a follow-up question: if you have a will and a trust, which documents take precedence? So typically when you have a trust, we usually have a will that goes with that, but the will is only there to make sure everything is transferred to the trust. And so in that case, the trust always takes priority, and the will does not control any type of distribution. So that's the situation there, is that even if you have both, the trust would always take priority. And the only exception to that is if you had a poorly drafted will that conflicted with the trust, which hopefully nobody would ever run into that. But the will does take a back seat to the trust when you have those done. And in your guys' case, that's how it would be set up, is that the will would take a back seat to the trust. Those types of wills, when you have a trust, are called pour over wills. So pour over, like pouring water, you're just saying that the will gives everything to the trust, and it doesn't have any control over the distribution of your assets. Any other questions? Hopefully that answered your questions, Kim and Karen there. And again, you guys are welcome to unmute at any time if you want to chime in or have other questions. Okay, I think I got all those. So of course we are here to help. This is what we focus our practice in, is estate planning and helping people and their families prepare for that and empower their families for success into the future. And so an estate plan with us includes all the documentation discussed in this webinar today. So it includes, wills or trust planning, depending on which direction you go. If people need asset protection strategies, we can take those into account and actually help protect assets from potential creditors, like Medicaid is the big one that we deal with mostly. We can do legacy planning for families, make sure that they, not only transfer their wealth, but do it in a way that can build a legacy for their family. And then we have a VIP program that allows for, continued access to us without additional costs and discounts on future services and assistance just throughout your life. Like one of our goals is to be lifelong legal advisors for our clients and to have that connection and relationship with them throughout their lives. And to be a positive and good resource for them. And so that's how we have helped kind of bridge that gap, is through our VIP program.